Okay, welcome everybody. We'll go ahead and get started. Thank you very much for taking the time to join our employment webinar. I understand it's a pretty difficult time for everybody. It's been different, everybody working from home, but hopefully today will help. Before I turn it over to Jeff and Peter, I just want to go over a few housekeeping procedures here, just to kind of keep everything moving along smoothly. So if anyone has any technical issues or troubleshooting, please use the chat feature and I will work with you directly offline. But it looks like everyone seems to be figuring it out so far. So hopefully there won't be too many of those. During the call, please keep yourself muted, just so there isn't any ambient noise going on while Peter is talking or answering any questions. If you don't know how to mute yourself, there should be a little button down at the bottom of your screens that look like a microphone. You can click that and it will turn red to mute yourself. And if you ever need to unmute yourself for whatever reason, you can just click that again and it will do the same. If you're calling in from a cell phone, you can do the same on your phone. If you do have questions that come up, please put them into the chat feature. The chat feature can be found in the top right-hand portion of your screen. It looks like a little thought bubble, and you can click on that and enter questions. Please be aware that those go to everybody. So if you want to keep your question a little bit more generic or private, just be aware of that as well. You may unmute yourself if you have questions or you're prompted to answer. That is perfectly fine. We did receive several questions prior to the webinar, so thanks to everyone who submitted those in advance. Just so everyone is aware, due to legal restrictions, Peter cannot give legal advice to non-clients. So what we're going to do for the questions that were submitted in advance is we're going to put them in a little bit more generic form, so that nobody gets in trouble, but we still get a basic answer for your questions. Last thing I have is there is a present feature on Google Hangouts. Please avoid hitting that button on your computer because we'll see everything you're doing on your screen. So I'm sure you won't want that as well. So with that, I will turn it over to Jeff Surratt and we can get started. Thank you.
Good morning. Thanks, Matt. Appreciate that. Once again, from all of us at the section office, we hope all of you are safe at home with your families and everybody is as healthy as they can be during this crazy time. We know that everybody's going through a really difficult period right now, whether that's personally and or professionally. Obviously 2 of our 3 states are not golfing. Our folks in Delaware are up to their eyeballs in golfers, I think, at the moment with golf. So again, please, if there's anything we can do at the section office to help any of you personally or professionally, please don't hesitate to reach out to anyone in the section office. We are all working remotely, obviously, but we are here for you if you need us. So to roll into our presentation this morning, so Peter Rosenzweig, Peter is a partner at Kleinbard LLC in Philadelphia. They are the section's attorney. I think Peter, now it's been 3 years, almost 4, that we've had a relationship. We explicitly retained Kleinbard once Eric Kennedy got on the board. So we felt like we needed some representation once he got on the board to make sure we were covered. So we're good there. But Peter has a BA from Penn State University. We are, right? All our Penn State alums on the call from Schreier Honors College. He also received his JD at the University of Miami School of Law. And he did practice law in Miami for a bit of time. Peter is originally from Montgomery County, so he made his way back home. He's dedicated his entire career to employment law and related litigations. In recent years, he spent a considerable amount of time on wage and hour issues and claims concerning overtime compensation under the FSLA and applicable state laws. He's been the lead counsel in multiple collective and class action cases around the country that have sought unpaid wages and overtime pay. Reached out to Peter a couple of weeks ago to try to put this together, and we tried to make it, we'll get some topics that are obviously as generic as they can be to the group. Obviously, we have a collection of exempt and non-exempt employees. We have independent contractors. I think on the call today, we're going to have some general managers or maybe even some owner operators. So Peter is going to try to broad brush this as best he can to give everybody a little bit of a quick education in employment law. He is based in Pennsylvania, so our folks that are in New Jersey and Delaware, the information that you do get today may be a little bit different when it comes to your state in New Jersey or Delaware, and Peter can get into that a little bit. And then obviously with the CARES Act just coming out, if anybody had a quick read of those 800 plus pages, you'll understand a little bit about what Peter is going to cover right now. So without further ado, I'm going to turn it over to Peter. Pete, thanks again. Really appreciate the time and the help today. So
great. My pleasure, Jeff. I just want to make sure if everybody can see me okay. Number one, I do want to echo a lot of what Jeff said in terms of, I just want to make sure that everybody is healthy and safe. This is obviously an unprecedented and crazy time, as we all know. So that's first and foremost before anything that I talk about, in terms of the general business scene and all of these new laws applied to business and what we do in particular, whether we're employees or independent contractors. First and foremost, we want to make sure that everybody is healthy and safe and continues on with that. Obviously, everything that we're going to discuss this morning has only come about because of coronavirus. If that had not happened, I don't think, or I know for sure that we wouldn't have been having this presentation, because all of these laws, again, that we're talking about have only come about because of the coronavirus situation. And for our purposes, how how these laws have direct applicability only to coronavirus. One thing which I do want to say is, Jeff did reach out a couple weeks ago to start our discussion about this and ask if we could do a webinar. And it is such a fluid and evolving situation, such that when Jeff and I first spoke a couple weeks ago, from that point until now, I can't tell you the number of changes and the content of the changes in these particular bills and laws that have come out. Primarily, what they deal with, and there's two laws in particular. First is the FFCRA. Now, I apologize in advance for giving you all these acronyms and abbreviations for the statutes. I'll certainly fill in as we talk. The FFCRA is the first statute that was signed into law probably, I think it was maybe March 17th. That deals with, we'll call it the health issues related to coronavirus and how those issues are dealt with within the workplace. So we're talking about paid sick leave and paid sick days. Whereas what Jeff just mentioned, the CARES Act, that's the Coronavirus Aid, Relief, and Economic Security Act, that came out more recently. That deals with what we'll say is money, stimulus coming into the economy on behalf of employers and employees. So those are, some of the, I guess what you call it, the main themes of what I'll try and talk about today. As both Jeff and Matt said, if there's any very important questions that come up while we're talking, certainly, enter them on chat and we can address them. Otherwise, when I'm done giving what will, this presentation, we can open up the floor for any other questions. I don't know if someone's screen just popped up with something, a little cartoon character. Or I don't know if that's just a filler.
That's just Jeff's little decoy or whatever.
Oh, is that what it was? I couldn't. All right, I got you. That's fine. That works. And another important kind of theme or topic that we'll talk about today are independent contractors, employees, and versus independent contractors and self-employed individuals. I know that many of our group fit into the category of self-employed or independent contractors, as opposed to what we know as, W-2 employees. So because, our group, a lot of people in our group fit into the independent contractor category, I'll talk a lot about application of these laws to them and what they'll be eligible for now, which they would have not been eligible for in the past. I know there are some, small business owners. We can talk about that, or how these laws are applicable to small business owners, what they might be eligible for. And then we can also address employees. I first want to rattle off quickly, a quick list of other laws and other topics that are relevant to this situation. So I'm going to read through that list quickly, and then we're going to address each one in particular. But what's involved here is the FLSA, which is the Fair Labor Standards Act. We're dealing with office work versus remote work, OSHA, Occupational Safety and Health Act, the ADA, Americans with Disabilities Act, FMLA, Family Medical and Leave Act. We'll talk about furloughs. We'll talk about layoffs. Importantly, we're going to talk about unemployment compensation in the various states. And then finally, we'll likely spend most of our time going over these two new statutes, the FFCRA and then CARES Act. So first, quickly about the Fair Labor Standards Act. That is the federal law that deals with overtime, for all hours over 40 in a week that we're going to get time and a half. The FLSA only applies to employees, all right? I have, seen that there's some questions about how is, what about exempt employees versus non-exempt employees? The general rule, and we're talking about these in, if I am out of work, if I'm exempt or non-exempt, how am I going to be paid, or am I going to be paid? And another thing, everything we're talking about deals with, am I out of work or am I unable to work because of coronavirus? Or, everything has to be related to coronavirus, not just a general, business closure. Another thing to keep in mind, I've heard a lot of questions in the last 2 weeks, is, your office being closed versus being unable to work. And there's been some confusion. The way the laws are written, it's a little bit ambiguous and vague. So people ask, what does that mean when my business is closed? Does that mean that my physical, workplace, my physical office, my office location where I have keys or an access card to get into the building, does that mean it's closed and I can't get in? Or does it mean, that business operations have ended? They are ceased. The idea behind these laws is you are entitled to these benefits and you're eligible for coverage under these laws if you are unable to work. As a result of coronavirus, are you unable to work? And what that does, it captures working remotely, or teleworking, meaning that even though your actual physical office is closed, if you can still work from home, which I think, the majority or a lot of us are doing now, you're not going to have any protection or be entitled to any of the benefits under these laws because we're still working. We're still able to work. If we didn't have the ability to work remotely, then we would classify as be classified as being unable to work, and thus not, and entitled to some of these protections. So there we're talking about, the kind of office versus working remotely. In terms of exempt versus non-exempt, and, am I going to be paid if I'm out of work? The general rule is for non-exempt employees, right? If you're out of work, you're not going to be paid. Non-exempt employees are only paid for the hours that they work. So if you're out of work for an entire week, you're not going to be paid for that entire week. Exempt employees, it's different. The idea with exempt employees, for the most part, is that they are paid on a salary basis as opposed to an hourly basis. For a non-exempt employee, it's easy to compute what that weekly pay is going to be. They say, all right, I worked 10 hours this week. My hourly rate is X. Therefore, We multiply 10 times X, and that is my pay for this particular work week. With a salaried employee, an exempt employee, if you don't work at all during the work week, you're not going to be paid. Even though, again, you are a salaried exempt employee, if the entire week you're off, you're not going to be paid. However, if you work 1 hour during the week, if you work a minimal amount of time during the week, you still receive your full pay, your full salary for that week. Let's talk about, move on to OSHA, the Occupational Safety and Health Act. And now this is only going to deal with those of you who are employers and have individuals and other employees obviously coming into your workplace. It won't be applicable if your actual workplace is shut down and you don't have anybody coming into the workplace. However, if you do, the Occupational Safety and Health Act requires us as employers, obviously, to provide a safe workplace for our employees. You can't have any conditions that would otherwise jeopardize their health. The only reason I raise this is because if we know of an employee who has the virus or is suspected of having the virus, and is just careless in handling it or addressing it, we have a requirement to protect all of the other employees in the workplace. So that may require us to have the one individual who is again either has the virus or something related to contracting the virus to stay out of work, and so that we can protect our other employees. The ADA, Americans with Disabilities Act. Again, that's going to be addressing, employers. The ADA protects individuals who are disabled. The employers required under the law to give them some type of reasonable accommodation. So again, this is for employers if we have a physical workplace. If an individual either has the virus or some other condition possibly related to the virus, and they come to us, it's our obligation as the employer to provide some type of reasonable accommodation to those individuals, which could require allowing them to be out of work for a period of time. The FMLA, it's the Family Medical and Leave Act, again, applies only to employers, and this involves employers with 50 or more employees, so I don't know if it's going to be applicable to everybody here. What the FMLA provides is if we have an employee with a serious health condition, he or she is permitted to take 12 weeks of unpaid leave, and we as the employer have to hold his or her job. Now, keep in mind that those 12 weeks of leave are unpaid. And the reason I raise this is because this statute, the FFCRA, which we'll go over in a little bit, that's an amendment to the FMLA. Because what that does is for the 12-week period, instead of being unpaid, you do get payment. As a result of coronavirus or certain other reasons that you're going to be out of work because of coronavirus. Let's talk about layoffs versus furloughs. Some people have asked, is it just a matter of semantics? Is it really just the same thing? And the answer is yes and no. What a layoff is when an employer doesn't have any work available, nor does it have any money to pay employees. So what the employer will do there is really lay off the staff. And what the layoff means is that employer-employee relationship is now done. The employees, you're not going to be coming back. And again, you're no longer employed here. The relationship is done, which then triggers your ability to go file for unemployment compensation right away. And again, unemployment comp we'll talk about in a little bit. On the other hand, a furlough, that's when the employer does have some work available, not 100% of what was available previously, but there is some work available, but there's not enough money to pay everybody. So in a furlough situation, the employer may say, all right, we're going to keep on 20% of the staff, 80% I'm going to have to furlough you, or everybody's just going to work 50% of the time. It's any one of these methods by which the employer can make sure that the available work is completed and it has enough money to pay those who have stayed on. The idea of a furlough is the employer says, you're going to go out temporarily. You're basically going to sit on the sideline temporarily. And there's an expected date of return. you're going to go sit on the, sideline for 6 days because we anticipate everything's going to pick up in 60 days. At the end of the 60-day period, you're going to come back to work. The idea with the furlough is that the employer-employee relationship is still intact. It does not end. There's not a severance of employment. So typically, before any coronavirus, in a furlough, because the individual is still employed, he or she could not then go file for unemployment compensation. Because we know unemployment compensation, as we'll describe in a moment, is when you're no longer employed at no fault of your own. But again, in the furlough situation, the employer-employee relationship has not severed. It's just that the employee is sitting on the sidelines for a period of time. Now, however, with the changes to unemployment compensation, a furloughed employee can go file for unemployment compensation. So whether you're laid off or you're furloughed, you can still go file for unemployment comp. And so this is one of these beneficial pro-employee or pro-individual changes to unemployment compensation that have come out now. It kind of gets me to a good spot. We'll talk about unemployment compensation, and then again, we're going to jump into the 2 new statutes. Unemployment comp, and here is one thing that Jeff brought up before. Unemployment comp is state by state. So every state's rules, regulations, and laws for unemployment compensation insurance or unemployment compensation benefits are different. So what I'm going to comment on today is Pennsylvania. One thing I will say is, and this is because I did see it in some of the questions that were presented in advance, and Jeff brought it up earlier, is about what if I live in one state but work in another? Or what if I work in 2 different states and right now I'm either laid off or I'm furloughed or I'm fired, I'm out of work? Where do I go to file for unemployment comp? That's another thing, that states' laws and how they deal with that are very different. But for the most part, they're basically these sharing agreements. So if I live in Pennsylvania and I work in New Jersey, the question is, well, where do I file? I could go file in Pennsylvania, and Pennsylvania may say, well, hey, you only live here, you don't work here, so we're going to transfer your claim over to New Jersey, and New Jersey will handle it. So again, those are also rules and procedures that are state specific, but what I recommend there is if you file in one or the other, those 2 states will handle it accordingly. So you're not totally out of luck, and you really can't make the wrong choice, because again, if you first file in the correct state, you're good to go. But if you file in the one that may not be handling it, they'll send it over to the other state. As far as unemployment comp in general, because in this situation, nobody is fired, right? Nobody's, going to be fired for any type of willful misconduct that would automatically make you ineligible for benefits. But because of layoffs and because of furloughs here, we're all able right away to go file for unemployment comp. I did see some questions before about, hey, I've been trying to file and it takes so long and I don't hear back, and what I submit online, it gets lost, or everything's so burdensome. The easy answer to that is, I know everybody's dealing with that. It's just because, at least in Pennsylvania, their system, their application system, their computerized system is so old, it's antiquated. Right now, they don't have enough employees there to handle all the claims. I think I read that just last week alone, 830,000 new claims were submitted. So I think just for that week, there were more claims submitted than all of 2019. So they are deluged with complaints, both telephonically and online. So just be patient with that, I guess. And rest assured that once you make your application and assuming that you're eligible, which I'm very sure you will be found to be eligible, the benefits will be retroactive. Typically, or prior to this, to be eligible for unemployment compensation, there are several criteria that have to be met. You had to have worked for a period of time prior to the application for benefits. You had to make a certain amount of money prior to the application. The majority of those eligibility criteria have been relaxed, right? Also, under Pennsylvania unemployment comp rules, there was a 1-week waiting period. So once you made your application and were found to be eligible, you still had to wait 1 week to get paid. Also, and importantly, is that while you were collecting unemployment comp benefits, you had an affirmative obligation to go out and look for other work, to find other work, because once you became employed again and were earning a wage, you would be cut off or ineligible for your unemployment comp benefits. With the new laws, those requirements are not going to be, they're not effective. So there's not going to be that waiting period, nor do you have an obligation to go out and look for other work. I think, and most significantly for our discussion, as we prefaced earlier, is that now all of us who are self-employed and independent contractors, we are eligible for unemployment comp, just like any W-2 employee. Before all of this, we weren't. Now we are. So you go in and you file unemployment comp, you're going to receive the same benefits and entitlements that any employee would receive. Let's now move, again, sorry for repeating, but these two main statutes. The first, FFCRA, that's the Families First Coronavirus Response Act. This deals with, or this was, intended to deal with, we'll call it health and sickness. So, if, God forbid, we have the virus, or being, seeking out treatment for the virus, have to take care of someone who has the virus. And also importantly, if we're an employee and we have to be out of work, or unable to work, if you have the ability to work remotely, if you're unable to work because you have to take care of a child who is out of school because the school is closed down as a result of the virus, which as far as I know, Pennsylvania, I think every school is closed down, then you're also eligible for these benefits that you get under the FFCRA. Now, and also what's employment or important about this, that it also applies, typically the FMLA only applies to employees, but now basically everything we're discussing, independent contractors are going to receive the same rights that employees have. So what the FFCRA provides, it's an amendment to what I talked about earlier, the FMLA, the Family Medical Leave Act, which provided that 12 weeks of unpaid leave. This amendment, the FFCRA, makes those 12 weeks of leave paid. And the way it works is as follows. The first 2 weeks of that leave, they say it's the first 2 weeks or the first 80 hours of that leave, you're going to receive your full pay. The remaining 10 weeks, you're going to be entitled to 2/3 of your pay. So again, unlike the FMLA, the 12-week period is now paid as opposed to unpaid. The first 2 weeks of this new paid sick leave is full pay, and then the remaining 10 weeks is that 2/3 of your pay. Also under the statute, the employer is required to hold your job. You can't be terminated during this leave period. So when the leave ends, assuming we're all back to some normalcy, and the jobs are still there, the employer by law is required to restore you to your position. I don't know if I haven't seen any chats. If anybody has any questions where we are so far, I know, I've spit out a lot of information, probably rambled on a couple points, but before we move on to the CARES Act, which I think might be most relevant for us in our discussion now, Jeff, is there any questions while we're going, or?
Let me look to see if there's something that's relevant on this side before we get to the CARES Act. I think, okay, on this one, if an employee is 1099, but also a partial owner, what options might they have to collect unemployment?
Okay. Well, now it's a good question because, as we said earlier, a W-2 employer, taking a very general step backwards, employees, all right, a true employee at the end of the year is going to receive a W-2, which covers all of the wages that were received that year. Independent contractor is paid by way of a 1099. Independent contractors, they're responsible on their own to pay all of their income taxes, whereas a W-2 employee, all of those taxes and withholdings are taken out during the year. Now, with these new statutes, being a sole proprietor and an independent contractor, you are classified now, how they define this, as an individual. An individual includes employees, sole proprietors, independent contractors. So the answer to your question is yes, you're wearing both hats, and you can go make applications, or go make one application, if you will, to unemployment comp. If you're in Pennsylvania, again, you go to Pennsylvania Unemployment Compensation Office, submit these applications. Now, because these laws have come out, and they're obviously very pro-individual, as part of this whole stimulus package, and as I said before, the eligibility requirements have been relaxed. I don't want you to, or I'm not trying to say that the eligibility requirements have disappeared in total. They're still there and they've been relaxed. So when you make an application, unemployment can still look at it and say, all right, well, what you've done and the money you've received as an independent contractor that you're now not receiving, we're going to give you comp for that amount. However, even though we have relaxed standards, relaxed eligibility criteria for sole proprietors, you haven't shown us enough that in your sole proprietor capacity that you'd be entitled to benefits. My suggestion there is go make the application and see where unemployment comes out on that. One pro, however, because of the situation, before this, neither sole proprietors nor independent contractors would even be eligible for thought here. But now there is potential eligibility. Any other steps? I saw some things pop up.
Right. Yeah. So second question, a number of our golf professionals are exempt employees and draw some kind of a salary from their clubs, but they also earn lesson income that's maybe not part of their direct salary. During this pandemic, are they able to go for unemployment benefits to those lost wages from their lesson income?
Yes. The idea with unemployment comp is for most part, for any reason that the pay you would normally receive has been lessened. For example, in a furlough situation where the employer says, look, I don't want you to go sit on the sidelines, totally, but just come in 3 days a week as opposed to 5 days a week. In that instance, the employee there could go seek unemployment for those 2 days that he's not receiving wages, whereas he would have received them before. So in the situation here where you have a professional who, his full compensation is based on the salary directly from the employer or the club, but also the salary or the compensation component from the lessons. So long as you have proof of how much you earned over the prior period of time from lessons, and you can show unemployment that, hey, on average on a weekly basis I received X amount, my full compensation X amount was composed of the proceeds I received, I guess, from individuals for lessons. You can make application for that too. So then you would be, the idea is you would be restored to 100% of what you were receiving before.
Great. So Dave McNabb, given all those cash lessons, he's out. He can't claim any of that because it's all cash in his pocket, right? Our man Dave. Just kidding, buddy.
One important thing to this is now, albeit everything is, like independent contractors, gig workers, other self-employed individuals, though you are allowed now to go make application, you still have to be able to show proof, that you had these earnings and that those earnings are now lost. With, paperwork or other evidence, real evidence that you earned this, because unemployment's going to want to see that. Individuals really, unemployment, they've been pretty clear that you just can't go in and take advantage of the situation. You're still going to have to show proof. Go ahead.
Just as a clarification, so you covered employers' options, right? You're looking at layoffs, you're looking at salary reduction, or maybe even a furlough. Just as a clarification, one of the statements that you made from a layoff perspective, a lot of our facilities now are laying off their employees under the guise that once the lights get turned back on, everybody's coming back. So you kind of made a statement in there like you're not coming back, but I think in our conversation when you and I had it, the big difference is when you lay somebody off, it ends the employer-employee relationship versus a furlough where you're still connected to the business.
Exactly. That's one of the, so let's talk, before all of this, in a layoff, the employer-employee relationship is done. This individual is not, at least, the individual is not coming back to work. Right? Basically, you're done, you're fired, we have no work for you, we don't have any money to pay for you, we're going to lay you off. Then that individual can go immediately file for unemployment comp. Whereas with a furlough, and I'm talking prior to coronavirus, a furlough is, I'm not laying you off because you are going to come back for a period of time. Again, as opposed to a layoff where there's finality there, where the employer-employee relationship is done. Furlough, the employer says, you're still my employee. We still have an employer-employee relationship. I'm not going to pay you, but go sit on the sidelines for 60 days. Because at 60 days, I know that I'm going to have received enough funding so that you could come back and we can resume your work and resume your pay. In a furlough situation prior to coronavirus, an individual cannot go seek unemployment comp, right? Because he would still be employed. There's still the employee-employee relationship. Sometimes that begs the question that, all right, if there's still the employer-employee relationship, does the employer still have to pay the furloughed employees, insurance premium and other benefits? The answer to that is no, but the employer, up to their discretion can certainly pay that if they want.
Okay. I'll get to this next question real quick, but everywhere that I looked, there was a bit of a difference between exempt and non-exempt employees when it talked about reduction of hours versus reduction of salary from an unemployment standpoint.
Okay, that's a pretty loaded question. What do you mean from an unemployment standpoint?
So when I go on the unemployment website, when we look through and trying to figure out, where we're going to go, ultimately, I think when it talks about reduction of hours, it's generally talking about non-exempt employees or hourly employees versus a club turning around and telling an exempt employee, hey, listen, we're just going to cut your salary by 30%. It's not necessarily a reduction in hours, but it's a reduction in salary.
Mm-hmm. Right. All right. So very easy answer and scenario for the non-exempt employees. Again, non-exempt, you're paid on an hourly basis. You only receive pay for the number of hours that you work. That's easy. You don't have to, you can still get the same hourly wage, but again, you're paid number of hours worked times the hourly wage. That's what we'll call your weekly pay is going to be. Now, as far as an exempt salaried employee, let's just talk about, pre-coronavirus. The deal there between the employer and employees, look, you're a salaried employee, you're an exempt employee, you're going to receive this guaranteed predetermined weekly salary. Whether you work 30 hours, 40 hours, 60 hours, 80 hours, whatever it is, it doesn't matter. You have a predetermined guaranteed salary. Now, however, because of what we're going through, the rules and the rights and obligations have shifted a little bit. So if me as the employer, for cash purposes, I can go to an employee and say, look, by virtue of the circumstances that we're in right now, I can only pay you 50% of what your salary was before. Same number of hours, but I have to reduce your salary. So that's legal to do. Everybody, we're in this at-will employment situation. I've actually had your particular scenario just come up, where an employee came to me and said the exact scenarios you described, Jeff, that I used to have a salary, just picking a number, of $500 a week. Now my employer says, I want you to work the same number of hours, but I can only pay you a salary of half the amount. That's legal to do. And I told him, I said, unfortunately, where we are right now, I don't mean to be, mean about it, but you should be happy that, at least you're getting 50% of your salary as opposed to zero.
Right.
So in that instance, now that individual can still go to unemployment.
Right.
And say, look, I was earning this, before, now I'm earning less. There could be an issue with unemployment if they say, all right, well, have you had any reduction in hours? Are you unable to work now where you're working before? So that's one of these unknowns. And I'm making a suggestion to everybody now to go to unemployment, make the application. We don't know what they're ultimately going to decide, but that shouldn't preclude you or scare you away in the first instance of having to go and just make the application. Right. All of this, we're in the unknown now. Yeah. We don't know these laws. The ink is just drying on these laws. So a lot, I wish I could give answers. I don't know. None of this has been applied yet. There's no regulations about it. There's no case decisions about it. We don't know in practice how this is all going to carry out or play out rather. But given the framework that we're dealing with, what underlies everything is the government wants to keep business alive, get money to employees, keep the economy going. So if there's ever issues later on that come up about this, I think they're going to weigh in favor of individuals,
right?
Employees, independent contractors, self-employed.
Last question before we move to the CARES Act. There was a question: is a caddy at a club considered a gig worker?
I think we might have addressed this a couple of years ago when we did our actually kind of that wage and hour, overtime presentation. Why would someone say, a gig worker versus just independent contractor? I'm not sure.
Yeah. No, it was just a question that was posed to me.
Yeah. And I don't know whoever, presented that question is, those terms are, synonyms, if you will.
Right.
An independent contractor versus, a gig worker. I think gig, independent contractor is kind of the term that we've used for so many years. I think in recent years, gig workers now been, I guess the more in vogue terminology. But the way the laws define it all being the same, self-employed, independent contractor, gig workers, it's the law, it's all the same.
And ultimately in that scenario, they're going to have to prove what their income was that previous year to file and be able to collect.
Exactly.
Okay.
Exactly. You're going to need that information, essentially that proof.
Right.
Unemployment won't just accept the word for it. But unlike, we'll say February 2020, you as the caddy, the independent contractor, wouldn't even be able to go to unemployment to make an application.
Right.
Now you can. There's relaxed rules, but again, you still have to provide some proof or documentation of what your prior earnings were. And then based on those prior earnings is what unemployment will say you're eligible for unemployment. And
Great.
Again, that's something, the number, the pay that you're eligible for, again, is state by state, varies state by state. I think in Pennsylvania, I think the general rule or general standard is you're looking at about 50% of your average weekly wage. That's what you would get through unemployment comp benefits. Unless you have another pressing question, that's a good segue. We can get into CARES.
Yeah. I think the rolling into CARES, there were a couple of questions in there that kind of talked about this additional unemployment benefit, through the CARES.
Right.
I'll let you roll
in
there.
That's CARES. All right. So just right when I guess we realized that we were in a pandemic. what the government first wanted to deal with was the health component of it. And that's what we talked about in that FFCRA, the additional paid sick leave. Now that the government got past that first hurdle, the next major part in what they call this whole stimulus package is this injection of money. That's what CARES is, this Coronavirus Aid, Relief, and Economic Security Act. So they get this money out, the stimulus out right away. There's money that's going to go to businesses, and then money that goes to individuals. Let's talk about, primarily let's focus on individuals. Deals, again, people who are out of work, who are unable to work as a result of coronavirus. All right. It applies, importantly, to employees and independent contractors. Pre-coronavirus in Pennsylvania, right, if you are an employee, not an independent contractor, but an employee who is found to be eligible for benefits, you're going to get, around half of your average weekly wage for a period of 26 weeks. What the CARES Act now does is as follows. If you are found to be eligible for unemployment, for the first 4 months of your eligibility, you get what you otherwise would have received from the state, and you also get this automatic payment, $600 a week from the federal government. So in that situation, but that $600 a week only lasts for a period of 4 months. So again, during this first 4-month period, you're going to get your state benefits and the $600. Now, when let's just say 26 weeks of our state unemployment comp benefits is a longer period than I think the 16 weeks of the 4 months that we're getting for that automatic $600 a week payment. The 4 months period is all of April, May, June, and July. So it goes up to the end of July. The law, actually, CARES Act, becomes effective tomorrow, April 2nd. So again, the 4 months is going to begin as of April 2nd. So during those 4 months, 600 plus what you're going to get from state unemployment. Now, everybody keep in mind, I think the hope there is that we won't even need to use that. Hopefully this all comes to an end in the near term, and we can all get back to work. And once we get back to work, then there will be no need to get unemployment either through the state or through this federal pandemic emergency unemployment. Now, when the end of the 26 weeks, so when our 26 weeks of state unemployment ends, we get an extra 13 weeks, right? And that extra 13 weeks is actually paid by the federal government, right? But another thing I should raise is those 13 weeks, that's paid at what our state level is. So just let me throw out an example here. Say that we're eligible. I make an application, and under Pennsylvania state unemployment, I'm eligible for $300 a week. I am entitled to that $300 a week under general Pennsylvania unemployment comp for a period of 26 weeks. All right. For the first 4 months, in addition to that $300 a week, I'm going to get $600 from the federal government through CARES. So again, for the first 4 months, right, which I guess is the first 16 weeks, I'm going to get $900 a week. When that $600 a week ends, so it's basically the last 10 weeks of my 26 weeks under state unemployment, I don't get the $600, but I still get that $300 a week. Then the federal government gives me another extension. So when the 26 weeks ends, for the next 13 weeks, I still get that $300 a week.
Hey,
So
Peter?
that's under CARES. Sorry, Jeff, did you have something? Or?
Yeah, there was a quick question. Do folks have to do anything additional if they're currently on unemployment to have the CARES Act supplement kick in?
I would, it's not addressed particularly, but I would still, I think maybe I did see something. Yes, go in and I don't know if you necessarily have to make a new application or you just give, unemployment, get in touch with them now. And I think they'll be, educated and understanding enough to just, kind of add on, if you will, or extend your existing unemployment comp. I think what may happen there is that I don't think you'll get a new 26-week period that you'd otherwise get under, regular, unemployment comp. I'll take a step back there, Kevin. I'm not sure about that. I don't want to give any incorrect information. What I would do is go apply there, see if they give you a new 26-week period, but then you'll begin to be eligible for the $600 a week payment from the federal government. And then still eligible for that additional 13 weeks that will go on to the end of the 26-week period.
Okay, thanks. Sorry about that.
Sure, no, not a problem. And again, I apologize for, I know a lot of the uncertainty in my answers, but just as I said earlier, this is so fluid and involved, and nobody's had any experience in how all of this is going to be carried out. So it's tough to give responses when you don't have any experience on how these things have played out. Other benefits, in addition to, I should say, even before the unemployment comp benefits, there was that immediate cash payment that the government made or is making. I don't know the exact date that these checks are going to go out. As part of the stimulus package, was to give that immediate cash payment to everybody, all these individuals who are going to be eligible. I think we've seen the payments, these immediate checks or direct deposits of either, I think it goes from, depending on your circumstances, $1,200 to $3,400 based on, how much you earned, are you married, do you have dependents, and those criteria will determine what your immediate cash payment is. Then you get the unemployment comp benefits as we described. Also for employees who have 401ks, if you need to take an early distribution, take money out of your 401k, you're permitted to take out up to $100,000, and you will not have to pay the 10% penalty that you would otherwise have to pay if you did an early distribution from your 401k. All right, that deals with employees. For others, self-employed, independent contractors, gig workers, everyone who fits into those categories, who doesn't have an employer-sponsored 401k, but you have an IRA or maybe a SEP, the same rules apply there. If you're going to take an early distribution, you can do so up to $100,000, and the 10% penalty that we would otherwise have to pay is going to be waived by the federal government. And finally, for employees and these other individuals, there's certain student loan relief. What you should do is, if you have student loans, get in touch with your loan provider or your loan servicer. I believe if the government, or if they are loans that have been provided or currently serviced by the federal government, you're entitled to these benefits. I'm not sure if they give full forgiveness, but there's certainly a period of forbearance. They're going to waive interest. So that's something that is available. You just have to get in touch with your loan provider to see if they participate in that.
Peter, real quick, the one thing that we have seen is that there are certain business types that have been excluded. 501c6 and C7.
Comp. I don't know if there's anything else. If you want to open it up for maybe, any questions that we have following.
Yeah, the one thing that had come up in a conversation with the folks at PGA, and it's relevant to some of this group, is that some of the benefits, depending on the business type, are excluded. Like in a 501c6 or a C7, right now it looks like some of those benefits in the CARES Act, those types of companies were excluded. And there are a number of our private clubs that are actually a 501c7.
Right. Yeah, I know you had sent me the message yesterday. Yeah, as we talked about, the statute is over 830 pages. So there are many businesses that are covered. There's many types of businesses, I should say, that are only receive certain benefits. There are certain types of businesses don't receive anything. So that's one thing that I promise you, I want to go take a look at separately, and I'll be able to get you that information. I didn't know if it's going to be applicable to everybody you were talking to today.
Okay. Cool.
I've lost my for some great, but I'll get that to you. I did see where it is in the statute.
Okay.
And then I'll get that specifically. You can get that out to who it might be relevant to.
Okay. I guess at this point, folks in the group, if you want to throw something in the chat, raise your hand, ask a question. Peter's here to answer what he can.
And again, I know I said it several times. I apologize for maybe rambling at points or repeating myself or being uncertain on certain things. But I think, like you, this is brand new to me and my other partners at the firm, especially given that the CARES Act was just signed a few days ago.
Peter, there was a question posed by a few, basically saying, I think under the CARES Act, if I remember reading something where someone was supposed to start a job pre-pandemic, and then now their job's been put on hold.
Right. You go apply, and assuming you meet the eligibility criteria, and I think you're going to have to show proof of what the pay would have been, but you're going to be eligible, or at least you can go make an application like other employees or other independent contractors who did have work and have now been separated work as because of the virus. But yes, those individuals should be covered. Go make an application.
So there was a question submitted. So for the stimulus, the additional $600 in unemployment, is that a flat rate, or will that be prorated to what your actual comp was?
Flat. Or flat. That's 600 for everyone. The only thing that is variable is the state unemployment comp, because again, that is based. There's a whole chart. If you can get on to Pennsylvania, it's the Department of Labor Industry on their site for the Unemployment Compensation Bureau. It has the whole chart. It's somewhat complex and burdensome, but it's, it'll give you, if you make a certain amount of money within that category, you'll get X% of whatever the weekly wages were.
Another question, can any business receive inside the CARE Act, payroll loan forgiveness if they've already taken to laying off their employees?
I'm sorry, if they what?
If they've already started to lay off employees.
Well, if you bring them back, the idea, a lot of this, a major component of the stimulus is the government wants to give, as employers, wants to give us money so we can stay operating, and they know that to stay operating, we need our employees to work, and thus we need to meet payroll to pay our employees to work. So the payroll forgiveness, I think they may be paying, covering 50% of what you pay out in payroll, if I'm correct. But the employees have to be working and you have to be paying them. So if they're laid off, obviously you don't have any payroll because you've laid off those people.
Got it. Question here, in a work sharing program, would they still be eligible for the stimulus, the $600 in unemployment through the CARES Act?
Again, that's one thing I saw. It's a smaller component. When you say, go ahead.
No, Brian, maybe shoot me an email with a little more detail and we can follow up with you in a more general sense instead of kind of working through this on the web call. Okay. What else we got here? Anybody else have any other questions for Peter? Oh, here we go. Trying to make this as general as we can, Peter.
Okay.
So, direct legal advice. Let's see. Someone's in limbo. Laid off on March 20th. Going to work since March 16th. Okay, so so basically, in a situation where an employee had a date where they were going to be laid off at a future date, and then subsequently got laid off prior to that, will unemployment compensation be retroactive? So let's say, for argument's sake, this employee was supposed to be laid off, wasn't supposed to be laid off until, the 22nd, and they weren't going to go to work since the 16th, and subsequently they got laid off. Dave, I'm going to have to follow up with you, buddy. I'll get this, Peter, because it's a little, want to make sure we get it right for you. So trying to make it as general as we can without him giving you direct legal advice. So DE, I'll get right back to you after the call. Okay.
Sure, that's fine. Yeah, and I would everything will be retroactive. I don't know if that answers that particular question, but once you go make an application, everything, your benefits will be retroactive, as of the date that you were laid off.
Okay. What general information do people need when they go to file, Peter?
How long they have worked. I think in a very basic sense, how long they have worked and what their earnings were. That's in a very general. I'm sure there's other, specifics that unemployment is going to want to drill down on, but those are the two main components. How long you have been employed, because that is one of the criteria in a general sense. Pre-coronavirus, you had to have worked for a certain amount of time prior to the application for unemployment to even be eligible for unemployment. I think you might have had to work for the previous year, or at least a certain number of quarters within the previous year or 18 months, something like, I don't know that criteria specifically. But again, that criteria has been relaxed. But you would have to show the amount of time that you have worked and what the wages were.
Okay. Anybody else want to fire anything out to Peter? Well, we got him. Man, you must have answered all the questions, buddy. That's awesome.
It's a lot of rambling. I apologize that.
No, we understand it's an incredibly fluid situation. I think it, as you said earlier, it seems to change every hour. So, well, I guess in that sense, Matt, why don't you close it out with some housekeeping stuff?
Sure. So as I mentioned at the top of the call, or maybe just in chat, I'm not sure. We are recording this. So if you need to go back to refer to this at all, the video will be live. We'll share it with the membership via email later this week. And if you have any additional questions, please reach out to me or Jeff, and we can work to get those answers for you. They'll be in generic form, as we mentioned, just for legal reasons, but we'll do our best to get the information for you. If you have any feedback for the actual webinar, please get in touch with me, because if there's any improvements we need to make, we'd like to do that, as we'll be offering several more webinars in the coming weeks on various different topics. So be on the lookout for that as well. And I believe that's all I have for now.
All right, cool. Peter, thanks again, but I really, really appreciate all the help, with our personal section business and with this webinar. I know it was a bit of a yeoman's task to try to put this together with the CARES Act being just signed into law. So certainly appreciate the time, and I know you're crazy busy, at the firm. So not lost on us, what you did for us today. So thanks, bud.
Thank you very much. And everybody be healthy and safe.
All right, everybody back at home and at your clubs, please be safe. Don't hesitate to reach out and give us a call if you have any questions about anything. We're here to help you however we can. And everybody have a great rest of the day. And Peter, I'll be in touch soon. All right. Thanks, bud.
Thank you.
Have a good day, buddy.